6 justices said yes, 3 said no, and with that single vote, the entire legal framework that courts had been using to judge gun laws in this country cracked wide open. That was 2 years ago. But what happened next just months ago is the part almost nobody is talking about, and it could determine whether the rifle sitting in your safe right now stays legal or becomes something the government treats like contraband. The dominoes are falling faster than most people realize, and if you're not paying attention to the courtroom filings that are stacking up across multiple federal circuits, you're going to wake up one morning genuinely surprised by what changed while you were not looking. Let me walk you through exactly what happened, what it means, and why the next 12 months could be the most consequential period for firearm rights in a generation. The case was New York State Rifle and Pistol Association versus Bruin, and the Supreme Court handed it down on June 23, 2022. On the surface, it was a carry case. It came out of New York, it dealt with permits, and it centered on whether the state could force people to prove a special need before carrying a handgun in public. But the rule the court announced in that decision went so far beyond carry permits that it essentially rebuilt the foundation under every firearms case in America. Here's what was happening before Bruin. Lower courts had developed a comfortable little routine. A gun law would get challenged. The court would tip its hat to the Second Amendment, acknowledge that yes, it does protect some individual right, and then pivot into a balancing test. They would weigh the government's interest in public safety against the burden on gun owners, and almost every single time the government's interest won. It was a two-step framework, and it gave judges enormous room to uphold restrictions by simply saying the state had a good enough reason. Bruin demolished that approach. The 6-justice majority said the correct way to evaluate a firearms restriction is to look at the plain text of the Second Amendment and then examine whether the government can point to a historical tradition of analogous regulation from the founding era or the period surrounding the ratification of the 14th Amendment. No more interest balancing, no more deference to legislative judgment on what is reasonable. If the conduct falls within the text of the Second Amendment, the burden shifts entirely to the government to produce a genuine historical analog. That might sound like a technical legal distinction, but in practice, it was a seismic shift. Suddenly, every gun restriction that had survived court challenges under the old balancing test was vulnerable. Every opinion that relied on the two-step framework was standing on ground that no longer existed, and every future case would be fought on terrain that was dramatically more favorable to challengers. Gun owners understood immediately that this was a massive victory, but here is the critical nuance. Bruin did not directly address rifles, it did not mention AR-15s, it did not strike down any assault weapon ban. What it did was hand gun rights advocates the most powerful legal tool they have ever had, and the question became how fast and how far they could push it. That question got a very loud answer on December 22, 2025, when the Department of Justice filed a lawsuit against the District of Columbia over its ban on registering AR-15s and other semi-automatic firearms. This was not a small procedural challenge or a narrow complaint about some obscure regulatory technicality. The DOJ went straight at the heart of the ban and asked the court for a permanent injunction, a binding court order that would prevent D.C. from continuing to block law-abiding residents from registering constitutionally protected firearms. The complaint built its argument on two pillars. The first was common use. The DOJ argued that AR-15 pattern rifles and similar semi-automatic firearms are among the most widely owned guns in America, held by millions of ordinary citizens for entirely lawful purposes, including home defense, training, and recreational shooting. Under the framework established in both Heller and Bruin, arms that are in common use for lawful purposes fall squarely within the protection of the Second Amendment. The second pillar attacked the structure of D.C.'s regulatory scheme itself. The district had set up a system where certain firearms simply could not be registered, but D.C. also made it illegal to possess an unregistered firearm, so residents faced an impossible loop. You cannot register the rifle, and you cannot legally own a rifle that is not registered. The DOJ characterized this as a constitutional trap, a framework designed to produce the outcome of a ban, while technically avoiding the language of one. This matters enormously because it was not some outside advocacy group filing this challenge. It was the United States government. When the DOJ takes a position in federal court, judges notice, state attorneys general notice, legislators drafting new restrictions notice. The weight of the federal government pressing against a firearms ban changes the entire dynamic of the litigation, and it sends a signal to every other jurisdiction with a similar ban that the legal risk just went up substantially. Earlier in 2025, the Attorney General had already signaled that the department was going to take Second Amendment enforcement more seriously. A dedicated Second Amendment section was created within the DOJ, then came the DC lawsuit. This was not an accident or an improvisation. It was a deliberate policy choice to move the federal government from a posture of defending gun regulations to actively challenging them in certain contexts. On June 2, 2025, the Supreme Court declined to hear Snope v. Bruen, the challenge to Maryland's assault weapon ban. On the surface, that looked like a loss for gun rights advocates. The Fourth Circuit had upheld the ban, and the Supreme Court let that decision stand. But what happened behind that denial told a very different story. Justice Kavanaugh wrote a statement explaining his view. He acknowledged that the challengers had raised a strong argument. He pointed to the fact that AR-15 style rifles are owned by millions of Americans and are legal in the vast majority of states. And then he said something that sent a jolt through the legal community. He wrote that the court should and likely will take up the question of whether these bans are constitutional in the near future. Justice Thomas was even more direct. He said he would have granted the case and would not wait any longer to decide whether governments can prohibit the most popular rifle platform in the country. Justices Alito and Gorsuch also indicated they would have taken the case. 4 justices publicly stated they believe this issue needs to be resolved, and at least 2 of them made clear they think these bans are constitutionally suspect. You need 5 votes to win a case at the Supreme Court, but you only need 4 to grant review. That means the next time a clean vehicle for this question arrives at the court's doorstep, the chances of it being accepted are extraordinarily high. This is the part that so many people are misunderstanding. The court did not reject the argument. It declined to hear one particular case at one particular time. The justices who wrote about it went out of their way to explain that the underlying question is not going away, and several of them essentially previewed how they would vote. Here's where the rubber meets the road, and where a lot of people are getting it wrong in both directions. If you live in a state that does not have an assault weapon ban, the combination of Bruin and the DOJ's enforcement posture strengthens the legal foundation under your ownership rights. The argument that commonly owned semi-automatic rifles are constitutionally protected arms is gaining momentum in the courts, and that momentum makes it harder for any future federal ban to survive legal challenge. If you live in a state that does have a ban, whether that is Maryland, California, Illinois, New Jersey, or anywhere else, these developments do not erase your local law overnight. Your state's restriction is still enforceable until a court with jurisdiction over your state issues an order saying otherwise. That is an absolutely critical distinction. The legal arguments are stronger than they have ever been. The trajectory is more favorable than it has ever been. But trajectory is not the same thing as a final ruling. And acting as if a ban has been struck down before it actually has been struck down is a fast way to end up in serious legal trouble. The phrase you need to understand is common use. It has been doing heavy lifting in Second Amendment jurisprudence ever since Heller, and it is about to do even more. The concept is straightforward. If a type of firearm is commonly owned by law-abiding citizens for lawful purposes, it is presumptively protected by the Second Amendment. The government cannot simply declare something unusual or dangerous when millions of people own it and use it responsibly every single day. This logic is what makes the AR-15 question so potent. There are estimated to be well over 20 million AR-15 pattern rifles in civilian hands in the United States. They are the single most popular rifle platform in the country. Calling them unusual in the face of those numbers is an argument that gets harder to make with every passing year and every additional unit sold. You have to understand the difference between a promising legal argument and an enforceable court order. You have to know your local laws even while those laws are being challenged, and you have to stay informed, because the next major filing or ruling could land with very little warning. That's it for today, folks. See you in the next video.